Hello, everyone. I am Kamaljeet, a regulated Canadian immigration consultant, and I'm back here again today with you to share about inadmissibility, in particular related to family sponsorship applications for Canada. These are also general points that will apply to all immigration applications if you're applying to immigrate to Canada or make any application to come to Canada. If you've submitted a sponsorship application to sponsor your family, the immigration officer will decide first if the person being sponsored is a member of the family class. And once they determine that the application is a member of the family class, or the spouse or the common law partner class in Canada class, the processing office will conduct medical, they will actually request medical, criminal, and security examinations to determine if the applicant and all family members, whether seeking permanent residence or not, are admissible to Canada. So this is a very important thing that everyone will be required to be examined at this point of time, when once this determination is made that the person being sponsored is a member of the family class. It is important that applicants submit all applications in accordance with the document checklists and all instructions in the application guides. These are provided on the IRCC website. If you are looking at that, you will find all the instructions in the guides. While doing this, just be aware that the officers continue to have the right. They have provided you with a document checklist. This is more of a generic checklist that is, and that is also country specific. You know, if you're coming from a particular country, they have their own requirements. You could be asked to submit some documents based on your country of origin. So, but other than that, the officer can still has the right to decide and request for additional documentation from the sponsor or the applicant at any time during the application processing. You know, he needs to be satisfied that the applicant meets all Canadian immigration laws and regulations, whatever that is required by the rules and regulations of Canada for a person to come to Canada. In these in all the applications, you will find another form that will ask for all the family members, information of all the immediate family members. So applicants must declare all family members when you're applying for permanent residence in Canada. They must also declare any changes in their family composition. Supposing if you have already applied and then in between there is a change in some situation, like including the address and location, whatever it is, but in case there is a change in the family composition during the application process, up to the point where they are granted permanent resident status, you must inform immigration office about all these changes. Be very mindful if you do not declare, at the right time, it could lead to some trouble. Permanent residents and foreign nationals who have not declared all family members in an application may be inadmissible for misrepresentation. So remember that. We also discussed a little bit about this in my previous video. All family members of applicants in the family class or the spouse or common law partner in Canada class who are described as dependents in the immigration regulations, whether they're accompanying or not, must be examined. So this is very important. If they're coming with you to Canada or they are not, maybe they never come to Canada, but they must be examined. And if there is a reason, that they cannot be examined, there is something, then you must explain that to the officer, that this is the reason, and give evidence that why this cannot be done. And coming to the examination, first we can start with the medical examination. Now, what is this examination? This examination and as well as it is a determination whether the person is, medically fit to come to Canada, or if they are inadmissible for criminal or security reasons. This needs to be examined. The officer may be satisfied that a person who is not accompanying the family member is not inadmissible for criminality or some security reasons based on the information that is provided by the applicant. But just remember, a medical inadmissibility can only be determined once the family member has a medical examination. The determination of whether the inadmissible family member is renders a principal applicant is the person you sponsored, the main applicant who is applying for permanent residence. Now, why are there these medical examinations? Members of the family class are medically inadmissible if they are likely to be a danger to public health or to public safety. So to determine this, medical examinations are held, they have to be taken. But there is an exception for the sponsored partner who is a spouse or a common law or a conjugal partner. And also, there is an exception for the sponsored or sponsored children who could be adopted, or the dependent children. So now let's take a look at, what does it mean to say that, they are a danger to the public health or public safety. And danger means it could cause a problem to the society. The health could cause some impact on the health of the people around. And also the cost that the government has to bear, the government has to take to support this person survive in Canada. So for these reasons, these medical examinations are important, and people must be examined who are applying for Canada. They have to be medically examined. Now let's understand the criminal and security checks. Members of the family class and their accompanying family members must not be inadmissible to Canada for security, human, or international rights violations, criminality, or organized criminality. Generally, all applicants and their family members who are 18 years or over must provide a police clearance certificate or a record of a non-conviction for the current country of residence, wherever they are living as of at the time when they apply. And if the applicant has resided in that country for 6 months or more, and the country where the applicant has spent most of their adult life since the age of 18, police clearance must be provided from these countries. And also note that the accompanying family member who is inadmissible will make the applicant inadmissible as well. And also note, even if the family member is non-accompanying, there are circumstances under which the applicant is likely to be still inadmissible. Who could be a spouse, a common law partner, or a conjugal partner, or sponsored or dependent children, or also grandchildren in certain cases, where there are custody matters involved. There are, you will have to prove your relationship if you say that, no, this person is inadmissible, but it should not impact my application. So you will have to provide some strong evidence of your relationship to prove your relationship with this person. You could also be inadmissible due to financial reasons. If you're unable or unwilling, unwilling means maybe you have certain some responsibilities, and you're unwilling to support yourself and your family members. You could be inadmissible due to these financial setbacks. In most cases, if you're sponsoring a spouse, partner, or a dependent child, there is no minimum necessary, there is a minimum necessary income scale that is usually applied for sponsorship applications. But in these cases where you're sponsoring a spouse, a partner, dependent child, this is not really required. But still, you should be able to prove that you are able to look after your family. You are able to support them once they are in Canada. So if you're sponsoring a spouse or a common law or a conjugal partner, you must not have received social assistance. Social assistance is a support that you receive from the government or the provincial government at any time. Actually within past 12 months, if you have received social assistance, you could also you may not be able to sponsor your family. And of course, but then if this assistance is based on disability, you have a certain disability, yes, then it will not have an impact. You could also be inadmissible due to misrepresentation, which includes providing false information or withholding some information directly related to decisions that are made under the Immigration and Refugee Protection Act. It's called the IRPA. And if you're, if this happens, you could also be barred to apply for another 5 years. So you have to be very mindful when you're completing your application and you're submitting information, because this information is a permanent record with IRCC, and you must be careful. Be as honest as possible. I continue to repeat in all my communication with my clients and in all my videos. Please be very mindful that you should not hide any information. Wherever, whatever that needs to be declared, that matters, must be declared and explained. And if you're found inadmissible, you will be denied a visa or an ETA, electronic travel authorization. You could be refused entry to, or also if you are in Canada, you could be removed from Canada in these in such situations. And please seek professional help if you find yourself in these complex situations while doing an application. You can always email us at the email showing in the video, and I look forward to sharing more information with you in my upcoming videos. Thank you.